Hi guys, it's Kathy. I hope you're doing well. It is Wednesday, halfway through. We made it halfway through. Hey Terry. Hey Terry, guess what? So at work yesterday, I can't remember if we had 2 or 3 buses, but I'm sorry, 3 or 4. We had 3 or 4 buses. I can't remember if it was 3 or 4. 2 of them were from Maine, and they were delightful. They were delightful people. And you know what they didn't do? They didn't throw popcorn all over the floor, which is rare, really rare. Every day there's popcorn all over the place. So most of the people get a full buffet. And then we also have this concession stand out front. And even though they have this full buffet that they paid for, lots of people go get popcorn too for the show. And they always dump it all over the floor every single day. But the people from Maine, delightful, except for the first table I went to, I have to go through this spiel because our buffet is all over the place. You know, there's hot food over in one corner and desserts in another and salad bar in another and soup in another and drinks in another. And so I go through my spiel, telling them where everything is, and they're like, okay, but where's the salad bar? I said, okay, you see that big thing over there that sort of looks like a big salad bar? That's the salad bar. They didn't appreciate my answer, but I just got done telling them where the salad bar was, so I had to get more descriptive, I guess. But they were delightful. They really were. All right. We're going to go do some court videos today. Maybe. If technology allows me to do some court videos today. So this is the adorable judge's courtroom, but this isn't the adorable judge. We're going to have to limp by with a different judge today. But we shall survive because we have a really nice pro se. Nice as in entertaining for us, not nice as in they're a nice guy. They're not nice like my buses from Maine were very nice. No Twitch today, guys. I won't do Twitch when Monica's gone. That's just rude. She'll lose her streak. Is Josh here? Is V here? It's very important. V, as soon as Josh gets here, or not, it's time. It's time to do it today. We're going to do it. We just have to wait for Josh. All right, here we go, guys.
Okay, good morning, everybody. This is Magistrate Court for Dawson County, Georgia, for 22 April. I have 2 civil calendars this morning, a mediation calendar and a hearings calendar. First, let me just figure out who is here. I'm going to start with the hearings calendar first. The first one was LVNV funding versus Wanda Davis. Nobody's here for that case, are they? Good, that got consent. Number
Jude, Twitch is like YouTube, so it's just somewhere different. You can go and watch videos. They have a lot of gamers on there, so you can watch a lot of people playing video games over there. A lot of the cool kids are over there. Anyway, if you watch my live streams and you get ads because you don't have YouTube Premium and you don't want to see ads, if you have an Amazon Prime membership, you're allowed to use that Amazon Prime membership to get 1 subscription a month on Twitch. And you can go ahead and use that to subscribe on Twitch and then watch on Twitch. And then you don't have to watch ads. I'm not asking you to go to Twitch, Jude. You don't have to go to Twitch. If it's just for ease and convenience, if someone wants to do that, it's there. Except when Monica's not here. Then we don't do Twitch. Because you know why? It'll break her streak. I'm not breaking her streak. No one can make me. I'm gonna miss my 3 views on Twitch today for her. Oh, that's awesome, Donald. Wait, so V, you were in there? Margaret, you were in there? Bobby was in there? So after the stream today, I'm gonna go into Discord, into voice chat on Discord. You are all welcome to come. I'm probably gonna say it a couple times during this stream, if I remember. And we can chat for a bit. All right, back to work.
2 is Capital One versus Jeffrey Knudsen. You're Mr. Knudsen?
Yes, sir.
All right. And it's my understanding that the attorney for Capital One is going to be appearing virtually, so we'll get to that. Thank you, sir. Next is Aaron Sunshine versus Linda Hudgens and Stan Hudgens.
Aaron Sunshine, sir.
All right, thank you.
Mr. Sunshine.
Linda Hudgens, Stan Hudgens. All right, we will see. And ET4 Dawsonville LP Transcendent Electra Management LLC doing business as Ark Homes for rent versus Stephen Charles Maltby, John Paul Dodd, and other occupants. Anybody I just named? Yes, sir. All right, thank you, sir. All right, I will come back to the hearing calendar in just a moment. Let me go through the mediations calendar.
Long live the Queen.
Number 1 is Capital One versus Abraham Nissen.
Good morning, Judge. May it please the court. Joe Pippin here for plaintiff.
All right, thank you. Tell me your name again, I'm sorry.
Yeah, it's no problem, Your Honor. Joe Pippin, P-I-P-P-E-N, Your Honor.
Okay, thank you.
Yes, sir.
Abraham Nissen.
Yes.
Oh, okay, all right. Number 2 was J.P. Morgan versus Danny Scarborough. Nobody's here for that, are they? Good, that has been supposedly settled. Number 3 was Midland Credit Management versus Anastasia Cohen. Anyone here for that case? That has been continued to the 6th of May.
Yo, Bobby and Donald are never patient with me. They pick on me for any tiny, insignificant little thing.
Next is Midland Credit versus Zachary Floyd.
That's my other one, Your Honor, here for plaintiff, Judge.
All right.
Exactly.
All right, thank you, Mr.
Thank you.
Floyd. And Mr. Pippin.
Don't tell me you watch Star Wars, Bren, because I won't believe it. I just won't.
Number 5, LVNV funding as successor in interest to Credit One Bank versus Angela Mulkey, a.k.a. Angie Cantrell.
I'm Angela Mulkey.
All right. And anyone here from LVNV? We haven't heard from them, have we? All right. Number 6 was Synchrony Bank versus Brenda Patterson. Good, that
Don't know
is
why this is in here. I'm going to bump
settled
this
by
forward.
consent.
No, you didn't. Lies.
I'm going to
Lies.
continue the one that's still on the calendar, so you'll get another notice and all the same blah, blah, blah in the mail that you normally get. But if we can get some indication from them that it's done,
Oh,
we'll let you know. If you don't hear anything else, I know it's
What happened? Why don't you have your earbuds? That's horrible. You poor thing.
a pain. I know it interrupts your life and your schedule, but the safest thing, if I continue it and if you get another notice and if you don't hear from, if all those ifs fall into place,
I am pretty proud
show
of you
back
as well,
up
actually.
one more time, and hopefully it'll all be done. If in the meantime we can find something, through another if at you, we can find something out in the meantime, or if you can light a little fire under them and say, hey, can you please tell?
It's the same story as Harry Potter. Orphan, lives with aunt and uncle. I mean, it's the same storyline. Star Wars and Harry Potter. They're very similar.
Dawson Magistrate Court to leave me alone, then that would also help us take it off the calendar. So it's not really your job to have to do that, but you know, it might save you having to come here again if you can get them to communicate with us and tell them everything's all done.
Yes, sir.
All right. What I will do, and I don't see any reason for her to stick around.
Excuse me.
I don't see any reason for her to continue to stick around, so you can go ahead and go, and like I say, if you do get another notice, do abide by it. But if you can get them to tell us something, then that may preclude you having to come back yet again.
Okay.
So I will, and the other thing is, I know y'all are working hard to. That's the important thing, is that you're trying to get it all done, and that.
Right.
That will be way less hassle in your life than having to come to court a couple of times. So I appreciate all that you're doing to try and get that done. So that's it. You can go ahead and go, and just help me remember to make a note of everything I just said. Okay, thanks. Do you? Yeah, we can go ahead and give you a notice now. Do I need to sign?
Nope.
Oh, okay.
Yeah.
Okay, moving on down. Next was Shane Moore versus Justin Picklesheimer. There's the parties here. All right, thank you. And that is it for our mediation calendar. Okay. If you were one of the parties called on the mediation calendar, what is going to happen? The law requires two things, one of me and one of you.
I sure
What it requires is meeting time. And it's not that...
Hold on. I'm looking for Mr. Sunshine. There he is. There he is. This is where I should have started.
To our hearing calendar.
Guys, what is your
Let me
favorite
first...
movie? Doesn't have to be sci-fi. But what is your very favorite movie? Listen, if you take the top best 1,000 movies and threw them in the trash, you would still never hit my favorite movie.
Aaron Sunshine versus Linda Hudgens and Stan Hudgens.
John?
You have, it's not your job to keep up with them, but have you heard anything from the Hudgens?
No, sir. My bet was they weren't going to show up.
Okay, well that was, let's, if you would come on up. And have a seat. We'll try and make this quick and painless,
Yes, sir. Yes, Your Honor.
or not. Quick and painless is always a relative term. It's never as quick or as painless, but.
Yes, sir. I'm here about non-payment of the rent and property damages, sir.
Yeah.
The tenant failed to pay March's rent, owed prorated April rent. They are out on the 13th of this month. I was not notified till the 16th, but they said they were out on the 13th of this month. They advised they
They did, Michael. They did. They're going to make an animated Firefly.
had prepaid, Your Honor, in 2012 for 2026 last month's rent. Unless they had a time machine, Your Honor, I don't know how they would know what the rent payment would be.
Yeah.
I have the original 2012 agreement. There is nothing in there. If you want to see a copy of that, Your Honor.
That won't be necessary. Just tell me the figure I have is $2,083 plus $160 for the court costs. Does that
Yes,
cover
sir.
everything, or has there been? Okay.
That's it. Yes, sir. That's the past due rent, the prorated amount, sir.
Okay.
Your Honor, and the court filing fee.
All right, and let's see. What about the premises themselves? Are they still in it?
No, sir. They vacated, they said on the 13th, I was notified on the 16th by the tenant that they had vacated. I would have loved to know that they vacated the week of the week
I hear Debbie does Dallas is pretty good too.
of the 13th, so I would have been in there sooner.
Yeah.
I was in there on the 17th, Friday. When I entered the property, Your Honor, they had multiple dogs, even though the contract originally set for two dogs. They had 4 to 6 at a time. My vinyl flooring was completely buckled. The urine smell was intoxic. It was just actually toxic, and all the trim work had been eaten and chewed away by the dogs as well.
Okay.
I have a quote for that, and that far exceeds the amount of the initial deposit and the pet deposit. There is also an obscene amount of trash and furniture left over also that I'm requesting. I have the quote for the vinyl flooring, the mitigation of the urine smells that I would like to pursue beyond the deposit amount as well, Your Honor.
Unfortunately, and I hate to do this to people, but it kind of harkens back to what I was telling the mediation people. What I have to go by is this would be a separate issue than and as you probably know from having been a landlord, security deposit stuff is its own animal. And what you would have to do if you did want to file a claim as far as damages that after you've been able to, as you say, get your property back and do what you need to do to it, you'd have to file a separate action for that. The dispossessory is basically catching you up where you're supposed to be as far as rent and rental expenses, not necessarily property damage, and then getting you possession of the premises back.
Understood.
So that I will do today. I'll sign this judgment. Like I say, it seems burdensome to me. It seems burdensome to all be put on you, but that's part of the joys of being a landlord. I've been both a landlord and a renter at times, but that would be a separate action, just because it would be. You'd have to go into the here's what the deposit was. Here's document all the damage and everything. And as you say, even if you have all of that now, I really can't hear all of that.
Your Honor.
So let me do this first. Case number 2026 CIV 0344, Aaron Sunshine versus Linda Hudgens, Stan Hudgens. Court finds, or Mr. Aaron Sunshine is present. Linda Hudgens, Stan Hudgens have failed to appear. There will be a judgment for plaintiff in the amount of $2,243 and a writ of possession, even though you already, have you gotten keys and
Yes,
all that?
yes, Your Honor.
Technically, you don't need the writ, but I think it is probably safer that one be in place.
Thank you.
And because without it,
I don't ever want to see a pub with no beer. I would never be interested in joining you if you guys ever went to a pub with no beer. I would not be interested. Don't invite me. It won't be okay. Don't say, oh, we can just talk. Just don't. Take me somewhere else.
I don't think this would be likely to happen, but they could show back up and go, oh, we want that sofa we left. Oh, and this way there can be none of that. So I'll give you those two pieces of paper here. Madam Clerk has just filed them in, and she'll give you a copy. The good news is that you won the judgment. The bad news is you basically leave here with a piece of paper in your hand.
Yes, sir.
And
Pursue collection.
getting your money is a whole separate thing. Again, it's not the fairest system in the world.
I understand, Your Honor. I asked for a 40-net address by them. They obviously ghosted me, so I wouldn't expect it, and they're not here today to defend themselves.
And in the long run, you might be better off washing.
Is there any way that this could be put on their record of eviction?
A writ does go on
Okay.
their record, yes. In other words, if they were to go to,
He just doesn't want them evicted. He wants to make sure that they can never rent from anyone else ever in their entire lives.
a rent from any kind of formal situation, an apartment complex, a rental, then it would be, it's a little more complicated for a private party if they're just going to rent from somebody they know. That person finding out that information is a little bit more work on their part, but it is there. So if any landlord goes to asks the question, they will find that there's been a dispossessory.
Thank you, Your Honor.
Good luck to you, and like I say, if you want to compile everything you need to, it sounds like you're already either have it or close to having what you need. You can file what's called a statement of claim, which is just the Georgia version of a small claims case. And right now, the limit, I don't know if it sounds like this might be an issue for you, but right now the statutory limit for this court is $15,000. If your damages are more than that, you'd have to go up to Superior Court. The legislature just raised it, but that hasn't gone into, or just passed the law, but that hasn't gone into effect yet.
Thank you, Your Honor.
Thank you. Sorry you're having to go through this.
Have a good day.
Thank you, Zach. 12 months, that's 1 whole year. Dear Lord. Thank you, Maiko. It was interesting. I'm gonna watch it. Who do we get, Zach? Who do we get? Yay! Zach, thank you very much. I appreciate it. Thank you.
All right, Mr. Maltby, if you would just come up to one of the tables. You can have a seat. Mr. Sunshine stood the whole time. He didn't need to do that, but just have a seat. Anyone here from Ark Homes?
Are you back in Florida now, Zach? Or are you still in Pennsylvania?
Debbie, could I ask a favor of you?
Yes, sir.
Because we used to do these in B and now we're doing them in A, could I ask you, I'm probably sending you on a wild goose chase, but could you just stick your head out in the hall and make sure somebody from Ark Homes isn't either out in the hall, or is there anything going on in B today?
We got all 4 courtrooms going on.
Great.
Yes, sir. You may ask over here and see if she got one.
Yeah, if you could ask us.
Don't set anything on fire this time.
Ark, yeah,
Zach?
just spelled just like Noah. Ms. Maltby, I appreciate you being here.
Yes, sir.
Oh, that's so cool.
10-4.
If somebody's, the reason we're just kind of sitting right now, I just want to make sure that they're not sitting in the wrong courtroom. That has happened before. And if nobody is here from Ark Homes, we go one way. If somebody is here, then we go another way. So let us do that real quick.
Okay.
This man was getting evicted, so he showed up to court today.
Ark Homes, good.
Zach, we have a flamingo at work in the little gift shop. It's so cute. I almost got it for you. It says the name of where I work on it though, so I didn't.
No, sir.
All right, I appreciate it. Thank you very much. Okay,
Ark Homes,
Mr. Maltby with,
Yeah. Somebody go wake up Josh. We had a plan. Guys, I've been cryptically talking about a plan for Monday's stream, which was yesterday, and it didn't work out. But today we're going to do it. But we just need Josh. And then all the questions you had about what I was talking about will be answered.
with nobody showing up.
Check the other courtroom too, so
Oh, okay, I appreciate it. What's going on? What's,
we got some civil cases.
Oh, okay.
Got a couple
okay, I was just curious.
hearings, preliminary hearings.
But you're so much like President Snow, Brent.
Just for...
I apologize.
Just for my clarification, did you say that Mr. Dodd has been in and,
That was a separate case.
oh, okay. Are you still living at this address?
Yes, sir.
Is Mr. Dodd still living at this address?
He's never lived there. He just helped me get the lease in my name.
Oh, okay, all right.
That's my brother.
Does anybody else live there?
My fiance and my
Zach, I'm so happy you were getting Colorado now because I didn't have time. I chose Indiana and Georgia. There is so much Colorado court. I kept telling them I could give them a new judge every day for the next X years because there is so much Colorado. Denver is a good place. Denver, you know what? You'll figure it out. There's so much.
three kids.
Okay. What's your... We're not really going to go into all of the details. I just so I have some background. How do you stand on the rent right now?
I've got right at 1,500 today, and I just need to the end of the month to get the rest of it.
Okay. Well, what I'm going to do, since they are not here, is I'm dismissing the case. So that doesn't mean, you know, you're...
Not paper,
Yeah.
I know.
It just won't be... Your payment will just be to them, and it won't have anything to do with the court.
Okay.
Because, like I said, all we can do is make things more complicated than they
I
need
got
to be. So yeah, if you pay what you can, do be aware that this is one of those funny things in the law where they are allowed to file again, or if they perceive another violation. You know, if in their minds there's a second issue, they can come file again. But they can file again on this. So if you do get something in the mail, don't just say, "Oh, judge dismissed that. I can ignore it." Like I told the other lady, the safest bet, even though it's a pain, is to always show up. And I appreciate your being here.
Yes, sir.
But anyway, I'm going to dismiss this case. They can.
Imagine that, being late for rent, getting your evicted, going to court, and then they don't show up. Maybe great. Maybe. Hi, Crystal.
Either file again, or you can get caught up and.
I plan on paying
Usually,
my payment today, and then get caught up by the end of the month.
Yeah, I was going to say, and if you get caught up, generally
They keep expiring their links, so it's not as easy to automate Colorado as it is for Indiana. Indiana, I press one button every morning and I get every court in Indiana. I get all of the dockets. Colorado, that is a lot of manual for me because I have to keep replacing the link.
is this an apartment complex?
It's a townhouse.
Okay.
Yes, sir.
Usually companies that do this are pretty vigilant about if they wanted you, if they wanted this judgment and wanted you out,
They'd be here,
there'd
yeah.
be somebody sitting there. I just, and that's why I wanted to just make sure we had one just last week where we went through all the paperwork for one way, and then
It was in another courtroom.
they were sitting in the wrong courtroom the whole time.
Well, I
and we
appreciate
kinda
you
had to
checking for me.
start everything all over. But anyway, so you'll get this. Madam Clerk will file it in, make you a copy, get it, you'll be free to go.
I
And,
bet he feels fantastic
we'll go from
right
there.
now.
Thank you.
Better than Mr. Sunshine felt.
Thank you so much.
All right, now we get to the pro se guy, I think. We get a couple pro ses in different courts today, guys.
All right, so that leaves, is it Knudsen or Knudsen?
Knudsen.
Knudsen, okay. I figured whichever I chose, I had a
So you got it
50-50
right,
chance.
most people can't get it right on even the second try.
Come on up. This will take me, given my superior technical skills, it's going to take me a minute to get, yeah, that's fine. I appreciate your patience.
No problem.
Because of all the things that can go wrong with any of the parties appearing virtually, that's why we usually do them last.
Oh, okay.
Oh, Martha, how are you feeling today? Is it a good day?
Mr. Green, I appreciate your patience. We have everybody here. Mr. Knudsen is present and is at one of the council tables. We can see you.
Granny, you know
For some
how...
reason, my camera.
Do you want to know how I learned Python, Granny? You can too. So, MIT has courses... Okay. edX. You can go to edX.com and you can take courses from MIT. You just can. If they're free, unless you want a certificate or something like that, then you can pay for the certificate. But MIT also on their website, they have this open courseware. So it's MIT OCW. All right, you look for OCW on their website. And they just have recordings of all of their, not all of their, they have recordings of so many of their classes. They're full semesters. You can just go to MIT and you can study anything they teach there for free. You don't get credits or anything like that. But that's where I first learned Python. It was in OpenCourseWare. It was pretty cool.
Keeps cutting off, but that really shouldn't. I mean, nobody needs to see me, so I don't think seeing me is that important.
Yes, that is the same.
Hey, Judge, no problem. Can you hear me okay?
Yeah, I can hear you, Mr. Knudsen. Can you hear him?
Yes, I can.
Okay.
The lawyer has
All
a
right.
lag. Just does.
So, Judge, this is just a, credit card case.
Right.
And we filed all the necessary paperwork showing the balance with the custodian affidavit showing how we got to this amount. The defendant had filed a counterclaim in the case, which the court has already denied. So we would just ask the court to rule on the briefs.
I got you.
I don't really have anything to add, in other words.
Okay. Mr. Knudsen, what's your position?
Waiting on Josh.
Just from the start with this, that they've not shown good faith. One of the points that was raised in the mediation part that's not been addressed, which was the counterclaim, was Discover Card made my card invalid. I had been making my payments on time. I did not miss a payment, and they decided to wipe away my available credit and make it basically where instead of having available percentage of credit available, it was 100% card usage, and my card was invalid from collusion from outside banks. My relationship with them, I was making on-time payments, and they did not have a reason to take away my available credit. And then when the first missed payment was made, the balance was only $71.90.59. That was the balance as of the first missed payment.
Oh, V, look. Brent just gave us a perfect opening. And we got to trash it because we need Josh.
Judge, do you want me to respond?
Go ahead, yeah. Yes, that'll be fine.
Hello, Beck.
Yeah, Judge, so that's, I'm looking at about 90 pages of documents that we filed showing the complete accounting of the case. And so I think, I'm not really sure what he's arguing about voiding credit, but the court can clearly see from all the paperwork filed that the last payment, was made, looks like,
Good morning, Florida, dude.
so I'm looking at a last payment at the time when the account was already around $7,000 that he owed. Excuse me, and that was from $127.89.
Yeah, but sir, you colluded with other banks. So he doesn't have to pay the $7,000 because you talked to another bank. V, if it makes you feel any better, he can't see yours either. I don't know why. I have no idea why. And my YouTube chat box is not working. I didn't even realize. So now you guys really can't see what each other is saying. I'm fixing it right now. There. Come on, YouTube. Get better. Get better, YouTube. I tried reaching out to them, but YouTube doesn't. They don't listen.
That's from the December 2024 statement. So I'm not sure how he can somehow claim that at the time that he made that payment, he didn't know that there was such a balance that was owed.
All right, and Mr. Knudsen, the part that I'm, I guess, having trouble understanding is them invalidating your card. How did that prevent you from continuing to make the payments that you owed?
They weren't in good faith, is they confirmed that they were talking with outside bankings to raise my credit and add, destroy my credit by working with outside companies. But I mean, the evidence, they've not addressed that. And with my counterclaim, they did not, address that. Yeah, they unfairly and wrongly removed my, available credit. The 11,
That doesn't answer my question. How does that prevent you from making the payments?
they didn't want to work with me to reinstate my credit card. They made my card invalid.
Again, that does not
Okay.
answer my question. How does that prevent you from making the payments? And as far, we're not hearing anything on the counterclaim. The counterclaim has been heard and dismissed.
Okay, and I don't understand why that wasn't even anything heard on their part, or on my part. But the other thing was just the last payment, the balance was only $71.90, and as of the first payment that I did miss, it was $73.20. And I mean, that's all, and I guess I further say.
I wasn't trying to make a specific argument. I was just stating that when he made his last payment, the balance was very high. So I'm not sure kind of what he's trying to say about us not trying to help him, but I don't believe he's raised a legal defense here to what's shown to the court.
Well, that's kind of where I am, Mr. Knudsen. I'm not unsympathetic to your plight, but you haven't presented anything that's presuming everything you say is true, that they acted in bad faith, that they colluded with other banks, and that they and I'm not saying that we're going with that. I'm just saying if I use that as an example and said all of that happened against you, that doesn't mean that you suddenly get to stop making payments. You receive the benefit of the purchases you made on the credit card. So you owe the money, and them doing, even if they did everything you're claiming they did, which you've shown me no evidence that they have, but even if they did, that doesn't suddenly wipe out your debt.
Snoopy. Hi, Snoopy.
The court fines for the plaintiff in the amount of $8,192.63 plus $110 in court costs. That's $8,302.63. That'll be the judgment of the court.
Your Honor,
Thank you, Judge.
Your Honor,
Yes.
it was just, but I did state that like $71.90 was the last balance that I received. And then the first one that when I didn't make a payment was $73.20.
Well, the evidence before the court is that was over a year ago. And again, that costs them money.
Yeah.
Your Honor, that concludes the case. Would I have permission to be excused?
Yes, and do we, I know Judge Myers usually does these things. Does he normally email you a copy of everything or mail it or?
Judge, if you just want to mail is fine.
Okay, all right, we'll do that. Thank you. I'm sorry you had to sit here all morning to watch me flail on the computer, but thank you.
You did. Thanks, Judge.
But Judge, it's not fair.
Mr. Knudsen, as soon as you get a copy of the paperwork, you'll be
Alrighty.
free to go.
So we didn't get our adorable judge, but we got a guy who went to court to get thrown out of his home, and he gets to stay there. And we got another that has a creditor in very bad faith. Let's go to a pro se in Judge Clymer. Then we'll go to a pro se in another Georgia courtroom. The accents aren't that thick, don't worry. It's not one of those courtrooms.
Brett Hobson versus State of Indiana, clause number 64 D02 1805 PC 4847, which is also related to 64 D02 9210 CF 143. Defendant is present by video from the Indiana Department of Correction. Pro se, state's represented by Chief Deputy Armando Salinas. Looks like we're here today for a status, Your Honor.
Mr. Hobson, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
If there's ever a time where you can't hear or understand anything, will you let me know, please?
I will.
And you are Brett Hobson, is that right?
Yes, sir.
All right. So here's kind of what the record reflects in that Mr. Hobson filed a motion for PCR, well, and he additionally filed a motion to modify a sentence, which I denied in a separate matter. The state did not consent to that. But in the petition for post-conviction relief, Mr. Hobson then filed an amended motion for post-conviction relief. And the state then filed a motion for a more definite statement as to what the specific allegations were.
CV, that's what I was worried about. Now Brent's leaving. And Beck might be leaving, and CJ's not here, and Margaret, is she still here? Is Margaret still here? We need the Australians to stay because they're the reason. They're the reason why we did this.
And then I ordered Mr. Hobson to set forth more specifics as to what it is that he was alleging that his claim for relief is based upon. And then he asked for a motion to compel to get evidence to support that. And that the last time we were together, what Mr. Hobson said is that the evidence that was provided to him in the box, I think it is the big box, was not the entire file or was not right. So based upon that request, I then ordered my court reporter to go through everything that she has to try to find any missing evidence to assist Mr. Hobson in order to respond to the state's motion for a more definite statement. And then my court reporter then filed an affidavit with the court, and I think sent that to Mr. Hobson on March 9th. And basically, in reality, it says she's listened to the tapes. Everything that Mr. Hobson has now is everything that she has. And I think she spoke with the then reporter, or the working tool of the then reporter. And there's no way for her now to recreate things that happened then because of the quality of the tapes. So what that means, Mr. Hobson, is right now she's giving you everything that she could find, and she's tried it 2 or 3 different ways. So I want to explain a little bit of the law. That those are just sort of the facts. So have I sort of explained to where we are accurately, at least is your understanding?
Yes, sir.
All right. Now, what you said.
Okay, now, when this guy starts describing what happened to his transcripts, I believe him. And I don't think there's any recourse. I don't know of what he could do. I mean, he can't fix it. They're gone. But I don't think there's anything that he can possibly do. Even if he got a lawyer.
Specifically, in your amended petition was a number of things. You said that your lawyer didn't object to certain things that were objectionable. That may be true. What you also said was that that there was prosecutorial misconduct in certain things that were said. That may be true as well. And what the state's response was is okay, not that they're agreeing with that, but if that's the case, tell us what specific questions that were asked that were objectionable, not just a general, my lawyer screwed up, but my lawyer screwed up by doing this, and this is what was said, and this is what didn't happen. And then based upon that, then I can rule. So right now, what I have before me is your request to throw out the convictions and verdicts and everything else based upon a failure to object. But I'm not sure at this point, object to what? I mean, do you understand kind of how my hands are tied?
That wasn't the only issue. I got my PC in front of me. That was not the only issue, though. What I have issues with, like you talked about the transcript that I was given. Okay, there was two things on there that I remember because it floored me that they.
Oh, V, I can't wait anymore. He gave us a second perfect opening. All right, V, I'm gonna go first. I'm just gonna go. When Josh gets here, he can do his own thing. But I'm gonna go, and you can go whenever you want, V. So the other day in evening chat, when we don't have very many Australians join us, I told everybody, I said, okay, for Monday's stream, Sunday night, I need you to all make an Australian dinner and discuss it in chat. So Monday rolls around and there I am. I forgot. That was yesterday. I had forgotten. And Josh didn't. I know what he made. He sent me pictures. And so last night I made for dinner a meat pie with tomato sauce. Now, for Americans, it's sort of like the little tins of the chicken pot pies you could buy in the frozen section. I didn't buy mine frozen. I made mine. And when they say with tomato sauce, they think the same ones with the beef in it. They put ketchup on top and then they eat it like a burger. So I made one. Now, I don't know what minced meat is, and I'm not going to. I'm not. I did not use minced meat. I don't know what it is. I think it's in a can. I'm not buying meat in a can. I'm not. So I just used chuck roast, and I made my meat pie, and it killed me to put ketchup. You have to put it right on top. The ketchup doesn't go inside or anything. You just squirt the ketchup on top. So I'm not gonna lie. I started eating mine without ketchup because it was so good. And then I did put ketchup on top, and I was unhappy with my decision, but I went full Australian. I put the ketchup on top. I ate a chicken pot pie with my meat in it, not chicken, like a burger with ketchup on top. Yesterday. All right, you had Brett Haas platter. I don't know what that is. Thank you, Beck. Because there's no way I was using minced meat. I'm just not. It took me 3 hours to cook the meat. I seared it and then I let it slow cook. And it was delicious. It was so delicious. I put, carrots, onions, and celery in it and let it slow cook. And it fell apart. And So I do like meat pies, but I'm not going to do ketchup anymore on mine. Nor am I going to, hold it like a hamburger anymore because that's just not how we eat pie. We use a fork. But it was good. So is that all Australian? These. What is Brettelhauser? No, Brettelhaus. Brettelhaus platter. And then I also know what Josh made. And we were talking about it in chat the other day. That's all I'm going to say. He's going to tell you when he gets in. But yeah, we all went full Australian the other night. There was no cheese in it. You don't put cheese in a meat pie. Although, I might try it. And bacon.
Actually did it. And I remember that. Okay, and that's the two things that I mentioned.
Okay.
Now, in 96, when I came back on my direct appeal, they dropped my murder to a manslaughter. Okay, the prosecutor was not happy with that. Okay, he had to do it. I guess his boss told him to do it. They dropped the murder to a manslaughter, and we were in the courtroom, and he said, good luck with the rest of the 120 you just got, the 120 years you just got. And I said, don't worry, I'll be back. And I turned and walked out the courtroom. He called the prison, Michigan City prison, had me locked up for threatening him.
This guy got a murder charge dropped down, and he's just angry and trying to, you know what, I get it. You know what, I get why he's doing what he's doing. We'll find out why. But he had a murder charge dropped down.
They locked me up. I was given my transcripts. Okay. The same.
So you had, wait. So you had the transcripts yourself that you're requesting?
I had the original. I just got them.
Oh, Beck, you can't call it a Parma. Because Brenna's going to correct you on that.
Okay, I went back to my room. The same two COs that came to my cell and locked me up that day I came back from court, came back to my cell and shook me down. Well, at Michigan City, when they shake your cell down, you stand out in front of your room and watch while they shake your room down. They didn't do that with me. They took me to the shower, locked me in the shower, went back, took every piece of paper out of my room. Okay, when I come back, they put me back in my room. I had not one piece of paper left in my room. So I went to the captain the next morning and asked him, when was I going to get the paper that they took out of my room back? And he said, you're not getting that back. You should not threaten prosecutors.
Oh, I don't know if he said that. I don't know if it goes that far. But he's in jail. He had the transcripts in his possession. His room got shaken down. They took all the transcripts from him. And now, if you heard from the beginning, if you weren't in chat getting distracted, they can't make good transcripts because the tape is bad. So they made the best transcripts they could from the hearing, which are not great. There's no way for him to get his transcripts back. None. So Parmy or Parma? I mean, listen, Parma sounds more correct only because Parmesan. But is it a Parmesan? Is that what it is? I don't know. But so anyway, so this guy doesn't have his transcripts. He needs this. The prosecutor right now is saying this guy put forth the motion, and he's saying there was prosecutor had done some whole bunch of wrong things in court, and his lawyer. Okay? The prosecutor is saying, prove it, show me the transcripts. All right? His transcripts were stolen. He can't get new ones. They want more proof. And that's where this guy is at right now. And there's no recourse for him. I can't think of the guards aren't going to give him back. They're thrown away by now. That was a while ago. So I don't know. This poor guy. But it gets worse. So we had a murder charge. We get to hear more. It gets worse.
They took my transcripts that day. Okay, them were the original transcripts. I never even got to read them. Okay, there's two issues I have with those transcripts that I remember from court. Now, one issue was my lawyer, the prosecutor told the jury that LSD was not a mind-altering drug. I told him to object. I told my lawyer to object. He told me he didn't know enough about it. But before I went into the court, he gave me he put in an intoxication defense before the trial even started, and then didn't even learn what I was intoxicated on.
All right.
Okay, that was the problem right there.
Okay.
He wouldn't object because he didn't know enough about it, is what he told me.
All right. So, Mr. Hobson, let me kind of go back to where we were. All of what you said may be true.
It is true.
All right. I'm not saying whether it is or isn't, but what I'm saying is that when I wrote the order that says give a more definite statement, you're telling me all these things, which are the same things that you told me before.
Right.
Okay. So put those in writing.
I did that. He should have it. I didn't send it to the court. I sent it to Mr. Salinas.
So do you have something, Mr. Salinas, that was not filed with the court? Do you know?
I have all right. For the record, the state has received handwritten correspondence from Mr. Hobson. It relates to this matter, but it also relates to other things as well. I would request that he file something with the court officially, and to the best of his ability. I understand, there may be some issues now with the transcript, but I just need just a little bit more information to respond.
Let me Mr. Hobson, stop for a second. I didn't know that you had sent that to Mr. Salinas, so listen to me. So rather than ordering you to send that to me, what I'm asking is that Mr. Salinas file a copy of that with the court so I can see what it is that you sent him. You don't need to resend it to me. I'm telling him to send to me and file with the court everything that you've sent him.
Okay,
So then I know.
I have a question. I'm not an attorney. I don't know a lot of the rules that goes on. I was just trying to do what you asked me to do, to give a more definitive thing. Now, I was under the impression to send it to him, not to the court.
I understand.
Okay,
I'm not saying that's right or wrong. What I'm trying to do is I'm trying to get it from him, what you sent to him. I didn't know he had it.
Then, from here on out, could you tell me where it has to be sent to?
I will do that.
I appreciate that.
Here on out, anything that you send to me, and then it becomes part of the record, and he gets a copy of it. So send things actually to the court clerk, and they get them to me. Don't send it to me personally. Okay.
Okay.
All right.
Okay.
Snoopy, I live in Pennsylvania. That's the #2 state for Easter candy. We love Easter candy here. We just love it. Of course, I don't have any peeps left.
Now, Mr. Salinas had some, based on what you sent to him, which I haven't seen yet, based on what Mr. Salinas has said, here, I'll let him say what it is that he was just going to say. Mr. Salinas.
Judge, I was just going to say that whatever's been provided to me, he would not have to resubmit. I'll make sure I file that with the court.
Okay. And then you were adding something else, I thought.
No, that's it, Judge.
So, having said that,
You'll have to pry them from my cold, dead hands. Nope.
Mr. Hobson, I haven't seen, and I still haven't seen what it is that you sent to Mr. Salinas, but
It's handwritten, Judge. It's like handwritten on toilet paper or something. He's in jail. All right, Snoopy, I can't give you any peeps, but Terry has snails. You can you can have some of Terry's snails.
will shortly. Is there anything else that you believe you need to send to either Mr. Salinas or me upon which we could have a final hearing on your case?
What you was talking about the tapes. Okay, I'm sure she's very credible. Okay, but me not being able to hear that tape myself is You know what I mean? It's hard for me to believe that tape is that nothing can be brought off of it. But I have a way to kind of rectify this. My co-defendant was tried right behind me. The same witnesses that testified in my trial testified in his. Can I subpoena the witness testimony that I think that would clarify this from his trial?
When you say subpoena the witness testimony, do you want to subpoena witnesses to testify here? Or
I
do
do.
you want records
I
from a
do.
different case?
I want the record from a different case because the witness I'm talking about is no longer alive. Okay, and I want to subpoena John Martin, who was my attorney at the time.
You know, he's now a federal magistrate
You should subpoena the judge too, sir. Just saying.
judge.
I do. I've read many of his decisions.
All right. All right. So here's what I'm going to do. I'm going to follow up on what I said last time. I can't give legal advice. I understand you're not a lawyer, and I appreciate that. I can't give you legal advice.
Can you give me a lawyer?
No, because you had a lawyer before, and you're entitled to one lawyer on your petition for post-conviction relief, and that lawyer withdrew. So
Because she said I had no merit because she has the wrong transcript.
Your answer is, can you get a lawyer? The answer is no. You had one before.
No, Brad.
Okay?
No.
That lawyer was to address all of those things that you had. Perhaps the same issues that we have now. I don't know. But the same thing that I just said to you before, every time we've talked, put in writing what it is that you want. If you want to subpoena someone, put that in writing.
So just the same way I did, I just filled out the paperwork. I just fill it out the same way.
What's happened is this. What the state has said, what Mr. Salinas has said is he wants a more definite statement.
He got that.
Well, and what you've just said to me is you want to subpoena people. So what I'm saying to you is put whatever it is that you want in writing and send that to the court. And then Mr. Salinas will see it. I will see it. And then he'll have an opportunity to respond. But that needs to be in writing so it doesn't change. It's something that's sort of permanent. So then 30 years later, somebody can't come back and say, no, that's not what he said. That's why it's supposed to be in writing. And it makes a record. Do you understand all that?
I do.
So what I want you to do, Mr. Hobson, is file something with the court clerk. Okay. And the court clerk then will send it to me and send it to Mr. Salinas. Don't send things straight to him. And I've told him to send whatever it is that you sent to him to send to me and file it with the court. And then based upon what it is that you request, we will then set a final hearing on the merits. Then the evidence will be whatever the evidence will be. But the evidence should be based upon the allegations that you set forth in your petition. And that is something that should have not, or there should have been an objection. There should have been an objection about LSD. There was prosecutorial misconduct. There was, somebody didn't tell you about a plea agreement. Whatever it is that you have, you need to set forth in details.
He doesn't get transcripts. He'll never even get a transcript of this hearing. Guards is going to take it.
What those are. Because simply saying you were denied due process, that may be true. I don't know. But there needs to be evidence to support that argument. And if you have no evidence, you lose because it's your burden of proof. They don't have to disprove something. You need to prove it.
Okay, now he's about to get into a conversation with the prosecutor. Here we go.
Do you understand that?
I do.
All right. How long do you think it will take you to send me something in writing through the court clerk that will say exactly what it is that you want or need or what your arguments are?
6 months?
Okay.
We don't have access to a law library back here where I'm at. So we have to do everything on our own. The ladies don't help us at all. So if we don't know what we're doing, we have to ask for help from other inmates. And when they're constantly moving other inmates, so when we get help from one person, he moves, and then all of a sudden we got to get help from somebody else. And then if there's nobody there, you're on your own.
I understand all that.
Now I have a question for Mr. Salinas. Can I ask that now?
He may answer it, he may not.
Mr. Salinas, do you believe in rehabilitation?
All right. I don't think that's relevant to this proceeding, sir, at this time.
Right.
I'm
But I do
just
believe
asking.
for the record, I do believe in rehabilitation, for the record.
Okay, I've been on this case, this sentence for 33 and a half years. How much more time do I need to do?
Well, according to the first judge, about another 100 years, but that was in part set aside. So,
He got over 100 years in jail. So that's why he's doing all this.
we're not here to discuss that today. We're here to see procedurally and evidence-wise what's going on.
You said I had to ask permission to ask for a modification.
Oh, I understand what you're saying. Does the state consent to the modification?
Is he going to consent to me doing a modification? What do I have to do? What do I have to do
No,
to prove that I'm ready for
No.
society? I've been locked up since I was a teenager. I'm 51 years old.
So as
What
it
else
relates,
what do I have to do?
so as it relates to your petition for modification, you don't qualify according to the rules because you require our consent and we don't consent to your petition for modification. Post-conviction relief.
I don't know what he did, but it was bad, guys. It was really, really, really bad. But he's been in jail for 35, 40 years already.
Is different. So if you're going to take this on pro se, then file the appropriate pleadings and we'll have an evidentiary hearing at some point.
So,
And I'm confused, man.
all right, now here. Well, what Mr. Salinas just said is there's two matters. The one matter is the sentence modification in the underlying case, and what he said is the state does not consent.
Okay. You know how I say, like Judge Mogan and Judge Frost. You know how I say, like, these judges know the law. Judge Mogan and Judge Frost, they just flat know the law. They don't have to look it up. They already know it. This judge is different. This judge, he knows the law, but he loves explaining the law. He loves teaching the law. So when you're in his courtroom, he will explain it to you. So he's in his prime right now. He's loving this case. Hi, Walter.
Without the state's consent, I have no ability to modify a sentence without the state's consent. And he just said the state does not consent. But what he also said is you have the ability to pursue post-conviction relief remedies, which is the other aspect, which we're still trying to do right now. And you've asked for 6 months, and I understand that your ability to access a law library is limited. But what I want to do is I want to set this for a status October 14th. And I will tell you this, if you don't have the ability yet by that time to find the evidence that you need, or tell me whatever it is that you want in writing, and then we will address that October 14th at 10 o'clock. And my office will coordinate that with the Department of Corrections so we can see you by Zoom, sir. All right? I can't give legal advice. I'll see you in October.
You're pro se, dude. You're
Have a good day.
You're on your own when you're pro se. Oh, it's not going well for the pro se people today.
See you this afternoon, Mr. Salinas.
It's because, Bren, it just sounds
Judge,
different.
Mr. Tavitas,
It just sounds different. Manslaughter sounds general, like a charge, maybe because we're used to it. Woman slaughter sounds bad. Really, really. Maybe we should start calling it woman slaughter because it sounds hard, and the charge is hard. We should sign a petition to change the name. All right, we're gonna go to more pro se nonsense today. Let's go to Georgia. Back to Georgia, but this is North Georgia, I believe.
Versus McCluskey.
Yes, Your Honor.
All right, and Mr. Hill?
And Mr. Hill is not here.
Okay. Did we get, let me make sure. I know I got some messages from some counsel. Mr. Morrow, come forward. Can you tell me the status of this case?
Yes.
And just so you know, folks, the court is looking to see which cases I need to schedule for trial versus whether you need a mediation order or if there are any anticipated motions that need to be heard. So if you can let me know from the defense standpoint, and I'm looking, Mr. Morrow, to see if we received an email from Mr. Hilt.
I didn't get a copy, but that's fine.
I haven't seen anything.
We've scheduled this for mediation, I believe, on May 27th.
Okay.
And it's not real complex. We might, if we don't settle at mediation, there may be a couple doctor's depositions, but we should be ready by July.
Okay. Ready by July if not settled?
Right.
Okay. All right. Anything else? Just, if it needs to be heard, just reach out to my office. Thank you. Charles Harris matter. Mr. Noble.
So we're watching this judge right now deal with lawyers. Okay? A normal courtroom. We're just watching a piece of normalcy. This is how it's supposed to go before the pro se comes.
Forward.
Judge, I have 2 cases against the Ports Authority on that calendar, and Joe Barrow's here.
Okay, Sonia Capers.
Yes.
All right, versus Ports Authority as well.
Yes.
All right,
And I think the announcement is pretty much the same. We've got some discovery still to do, and then we would like to get the court to do a mediation order, or we could do a scheduling order perhaps, just whatever.
Yes, if you want to submit a scheduling order and you want both cases mediated, is that?
Yes, ma'am.
Okay. Anything from you?
Yeah, Tim Roberts on behalf of Tyco in the Harris case. Yeah, I think what we're talking about is we'll get together and submit a proposed scheduling order next week.
Yes.
Okay.
All right.
Thank you. Thank you, Judge.
Okay, so do you want a separate mediation order, or you want to put a deadline to mediate in your proposed scheduling?
We could just put the mediation in the
Okay.
in the scheduling orders if the court
Okay.
doesn't mind.
All right, thank you. And sorry for your wait, everyone. Thank you.
Thank you.
All right. Thank you, Your Honor.
Thank you.
Have a good weekend.
You too, thank you.
I wish I could build up some equity for next time I'm late.
You can,
Okay.
you can.
Not with
Shannon
Judge
Neal
Brown,
versus
sir.
Anesthesia Consultants of Savannah. If I could get appearances, because I am not familiar with most of you.
Michael Johnson on behalf of the plaintiff.
Okay?
Olivia Adams on behalf of Dr. Darman and Anesthesia Consultants of Savannah.
Olivia Adams. Okay, thank you. All right, counsel, status of this case, please.
The case, on behalf of the plaintiff, the case is ready for trial. I understand from defense counsel a few minutes ago that they filed a motion for summary judgment today. I haven't seen it, but
Neither have I. They said they filed it today. Okay.
Yes, Your Honor. This was filed this morning. Again, I joined this case, I believe, in February, and we viewed for summary judgment on causation. However, the court would like us to deliver a copy of that for your consideration. Otherwise, we are, depending on the outcome of that.
I'm older than Google.
We are looking at a special setting possibly in early 2027.
Okay, if you could drop off a hard copy if it's over 10 pages long.
Yes.
That would be great. Thank you.
Your Honor, the case has been pending since 2019. And I understand from defense counsel that they want to try the case sometime in February of 2027 because Mr. Huff, who is lead counsel for the defendant, is busy between now and then. I don't really understand that, but I would just ask that the case be put on the next trial calendar, and if he can't make it for whatever reason, he can file a conflicts notice.
All right. Well, I'll definitely have to, if the motion has been filed, which I don't see it. Madam Clerk, are you able to tell if it's in the queue in SPCV 2300482? Okay.
Yes. Via e-file.
You don't? Okay, you may want to double check because we don't see anything.
Excuse me, Brent, sir, but you need to respect your elder, sir.
I don't see it on my end. She can see it even if it hasn't populated into the case yet, and she's saying she doesn't see it either.
Okay, I can confirm that we've served that on opposing counsel, and perhaps the filing has not been accepted yet by the clerk. But yes, we will deliver that as a hard copy to Chambers.
And I will...
Poor kids had to walk through shag carpet to get to that TV.
Get a trial date set. Obviously, I'll have to build in time to allow for response time to the motion for summary judgment. And to be honest, it would probably be at the earliest closer toward the end of the year, given the court's schedule already. If you want to submit a proposed scheduling order, if there are any depositions or anything else that needs to be done closer to trial or any supplementation of any records, I'll be more than happy to entertain that.
I don't expect any of those things other than the response to the motion for summary judgment.
All right, thank you.
I look back, it was filed at 12:23.
Okay, she does see it. Okay, great. Thank you. All right, and I'll take a look at that. And if anyone is requesting oral argument, you know that needs to be a separate request. And make sure a copy is sent to my office. Okay.
Thank you, Your Honor.
All right, thank you.
May we
Yes,
be
thank you.
excused?
And again, sorry for your wait.
CJ sent me
Calvin
some Tim
Daniels
Tams.
versus Russell
They were
Lavender.
delicious.
Mr. Schmidt. All right, and Mr. Daniels. Mr. Daniels, hi, you do not have an attorney, is that correct?
Yes, ma'am.
No, he's
You
per
do,
se
or it is
judge.
correct that you do not? You do not, okay. All right. And it looks like you filed a motion to dismiss back in 2023. The court's denied that. I don't believe there are any outstanding motions. Correct me if I'm wrong, Mr. Schmidt, from your end. I don't see any.
Judge, there is a matter that's not been resolved. The court entered an order compelling the plaintiff to furnish discovery. There's no compliance with the court's order.
Okay. Let me see, that's the last order.
And it puts us in an awkward position with respect to figuring out what the basis for the cause of action is and preparing for it.
I like slammers.
I gave a deadline of August 9th, 2024. When I didn't hear anything, I assumed it was resolved. That has not been resolved?
Not been resolved.
You know how to properly get that before me and to give Mr. Daniels notice. Mr. Daniels, it appears.
Judge, did you just slap down the lawyer in the pro se case? Slap down the pro se.
That the court ordered you to comply with the discovery request back in August of 2024. You understand? No? All right, well, I'm not able to give you legal advice, but I will tell you this. You don't comply with discovery upon proper motion, then this court can dismiss your case, okay? Discovery is the opportunity for the other side to learn more about the nature and the basis, the nature of and the basis for your allegations. And by law, you have to comply, okay?
Yes, ma'am.
All right.
Also, Judge, there's another case that's related to this matter, I think, that's also pending before the court. It's styled Lavender versus Daniels. SP CV 21-0184-CO.
CV 210184.
-CO, correct.
Is there not another number?
That's the one,
Is it 00184?
that's right.
Okay.
I'm sorry. And that case has been through some stages because in that case,
He stopped streaming. I
defendant
think.
is represented now by counsel. One of the defendants passed, and now there's the administrator, Ms. Daniels, who's here, I think, today. We went to mediation. Thought we were close to resolving the matter. I've reached out to opposing counsel on 2 occasions and tried to resolve it. I've heard nothing whatsoever. So what we'd like to do is try to move that case along first before we try to work on this case.
Oh, that was Mr. Amison is on the other
Yes.
side on that case.
So maybe if we could put that down for a date similar to today,
Okay.
we can move it along.
All right, I will do that. Can you send Ms. Baker a message for me on that case? All right, thank you. All right, Mr. Daniels, strongly encourage you to take a look at the court's last order that was issued back in 2024 in this matter. Mr. Schmidt, you know what to do if you still have a concern that discovery is not being complied with. Okay, any change to your address?
Oh, he's in trouble.
Okay, all right.
Thank you, Judge.
Thank you.
He's in trouble if he doesn't get that discovery, and he doesn't even know what it is. How much time do I have? All right, we have time for one more.
After Mr. Long filed his report, so we could discuss how we should move forward. Mr. Long had made some suggestions or recommendations in the report. As well, one of you filed an intent to relocate.
Okay. Okay, this right here is a child support hearing, I think. It's either custody or child support or divorce. Or all three. I don't know. And so like it goes by and it's really hard to understand what's going on. But every once in a while it drops a nugget, a bomb. So every once in a while you're gonna hear some, oh, what did I just hear? What was that? And then it'll go back to kind of being sort of confusing, and then boom, another bomb.
Because I went to JJC just so they can like have the correct address, because I thought like Sam was gonna start paying some child support. So that's what that was about. Eric and we went to JJC to make sure like we had the correct address and stuff. And that's all.
Okay.
Okay.
So there was a notice filed. I don't see, I don't see any objection to that file. I did see, Ms. Liz, that you filed something as proposed order. It looks to be an inappropriate document or inappropriate filing, so I struck that. That was back on March 16th. Mr. Liz had filed on the 25th a motion to appear remotely. I denied that, as I had ordered everyone to be here in person. So I have no information about why he's not here. Now, Mr. Longley, in your recommendations, let's start by first asking you, have there been any changes in what you're recommending?
Your Honor, yes, it was not Ms. Liz that filed that agreed order. It was myself that filed the agreed order based on the dispute of custody. It was all parties that signed it with a child support worksheet and file.
No, I said the hearing after you filed your. You filed your report on January 7th, 2026, and I set the hearing after receiving the report. You made some recommendations in your report, including that Jessica and Eric should join you, assuming Jessica is the primary spoken parent for Vidal, Eric, the primary custodian for Melina, and Sam, a visitation with Fidel, will be agreed upon by the parties. And if unable to agree pursuant to the parenting and guidelines, and that Sam worked to get more involved in Fidel's life, including school and medical appointments, and then the parents learned to work together as a team, and all other orders, if not modified, remain in effect. Those were your recommendations.
Yes, Your Honor, and after I filed those recommendations, later I filed an agreed order that the parties had signed with the signed child support worksheet.
When did you file that?
I believe that's the one you struck in March.
You filed a document entitled Emergency Custody Order, confirming the Department of Corrections.
No, I'm sorry, I apologize, Your Honor. I filed what was labeled agreed order.
I do not have anything like that after the January 1 date. So
I apologize, Your Honor. I thought this went through. Maybe it didn't go through the queue. May I approach?
Please.
Please. I thought this went through you. Apparently it didn't go through the queue. I don't know if it was on my end or Tyler or where. The parties together and it's about agreed order. And I think that's the basis of the Rainbow State.
Okay. Well, this is going to give me moments with this, right?
This is just black coffee. No cream, no
Well,
sugar.
this,
And I got my next one ready.
That I was planning on talking about today. Mr. Longman, is this the court's copy?
Yes, Your Honor.
Okay. Okay. Mr. Brown, anything else I should know?
Oh, what?
Anything else you want to tell me? Or anything, any concerns?
No, nothing
Everything
more.
makes sense?
Eric is gone. I have no more concerns, no worries, nothing.
Okay. This says that Eric has joint custody of both of them. That's secret. And then you're getting child support for Fidel.
How does he have joint custody of Fidel?
That's what the agreement you signed says. Mr. Wan, am I misunderstanding here?
No, Your Honor, that's what I was.
The lawyer has no idea what's going on. None.
Before they wanted to agree to, I typed it up. I submitted it to them. They signed it. And I thought I had filed it. I must not have understood what that meant. I wouldn't have signed it to give him joint custody of Adele. After I fought so hard, come after all this, I wouldn't know. Time it was signed, I believe. The police were living together, or they were living together at the time it was signed.
Right. Ms. Liz, is there anything I should know? Or anything else? Are you still in agreement with this?
I don't have a problem with it, but I just wanted to state Eric and I were not together, not living together, and Melina's with me. I haven't really heard from him because he just didn't go to his court dates, like from the other county.
It's totally real.
And
It's actually
didn't have no intentions of doing that, so we had a warrant and he's back with Sarah, so I don't have a problem with the agreement, it's just different. And I have not received any child support from Sam at all.
I was not aware of those last factors, Your Honor.
Of course you weren't, lawyer. You're useless.
How does this change things, Mr. Wan?
What?
What you have forward you propose, Mr. Wan, in terms of you said you're not aware of those factors, how would it change what your recommendations were? Or do you need some more time?
It would, this point, Your Honor, it would seem to me that mother has primary physical custody of both daughters.
All right.
And I would, since mother is providing the majority of the care, I think she would communicate with them if Mr. Sleece and Mr. Ramo talk to her or ask her or have any issues for mom, has any issues about medical. So I would say that it still remain joint legal for both girls with mom and both dads. So Mr. Ramo have joint legal, mom be primary custodian, father or Mr. Ramo have as agreed upon if they can't agree in the very time guide things. And for Mr. and Mrs. Solis, mom have primary physical, dad, and they have joint legal, dad have their as agreed upon, they have very time guidelines if they're unable to agree.
I'm in agreement that it wasn't filed. But I have no reason to doubt that all three adults, as well as the guardian, lied on. Well, all three adults agreed to this proposed program.
Lucy, hi Lucy.
And now I'm missing one of the parties.
Yep.
Mr. Eric.
Mr. Eric did not show up.
And Mr. Memo was telling me he didn't understand that Mr. Sliz would have custody of Fidel.
Don't forget that the lawyer had no idea about anything either, Judge. You should add that too.
All right. But Ms. Sliz continues to ask for the custody to be modified. That's what we have many hearings about.
Yeah, it's, yes, that's what I numerously asked.
Right, okay. Here's what I think makes sense. I'm trying to decide whether I let you all have a chance to talk. With mediator.
Judge, if you send it to a mediator, listen, Judge, nobody has any idea what's going on right now. None of them. And one of the parties isn't even here. So, sending them to a mediator would be putting this whole thing back to square one.
But with Mr. Sliz not being here, I don't know how to schedule that in. Or if I just set this for a hearing. And I think I'm going to just set this for a hearing.
Smart.
Smart. Sliz your hands up.
Yeah, I just wanted to add, the reason like things have worked out with Eric is because Eric has, well, he just has no intentions in coming to court.
No.
Okay.
I'm also going to set Alicia Hawes here because I told him to be here today.
Oh, he's in trouble.
And he was not. And if he does not show up at that next hearing, I may issue body attachment. Some other signature. I think if I gave you all until the 24th, that's 3 weeks in a day. If you wanted to discuss and have an agreement that you all agree to and understand, that's fine, we can be, But if you do not, then we could have a hearing, particularly on this issue of joint custody. And I think we should child support is no longer in question for you, Mr. Reynolds, right? Was there, Mr. Lund, was there also a child support worksheet that you intend to give the court for Mr. Siddis?
I handed it to you.
All three one, Mr. Brown.
Apologies.
Yeah, but what about Sarah, Judge? You didn't rule about Sarah.
It might be that Mr. Sliz, I don't know if they did not understand what's not saying about the city of
It's totally real.
I don't know what you said. I didn't understand this. It's not here today. So I'm talking here in person. So I know what
Maybe they eloped.
and my intents and the order of things. That's going to be reflected in today's order. So. Did you have that other document?
I did not, no, I don't have my staff file it right. House support has it, but I had it.
Okay.
But it was attached, but.
Okay. We'll just look out for that. For the purposes of today, I'm going to call this Exhibit A, or Mr. Lumley's handed me as Exhibit A. So that it's noted in the record what it is. And I do believe that you all signed this, but I think it's a concern how circumstances have changed, like you said, Ms. Liz, and if you didn't fully understand what's true. So let's get this on the calendar. I am looking at April 24th, as I said to you. That's a Friday. If you all could be here at 9:30.
There was no hearing
I have
at
a mediation
9:30.
at 9:30, Your Honor. I can do the afternoon. 1:30.
Sure, Judge. I see you're very good content, it's fun. How urgent is the situation? The children will say that.
We're all getting along, like,
Yeah.
only piece is missing is just Eric, and he just, I think, went back to Milford or something. No, I said, we're getting along, like, he takes Fidel every weekend, the kids are happy with me, I haven't taken care of them by myself, it's just the only piece that's missing is Eric, but it comes to a problem because Vidal doesn't feel safe around Sarah and she's back in the picture. So that's the issue, but everything else is going great.
Okay. So I shouldn't worry about making this urgent.
Oh, no.
I have a very large hot water heater.
I was hearing on May 1st. And now we Judge Bowes. I am not available that day because I have a meeting. That is also a possibility. I'm inclined to have you on a day when I'm here since I had other hearings with you all, but if you wanted to have it on May 1st, we could.
I'd rather have it with you.
The spring and summer counts just get so full. Actually, I'm putting What about May 19th then? Mr. Lyon?
I'm looking right now, Your Honor.
And, it would be the afternoon, so you.
I'm in trial in a TPR, Your Honor.
I'm sorry,
I'm in a TPR trial
all day?
all day.
Is he really needed though, Judge? I don't think we really need him to come. I don't even know why he's there. Oh, don't tell me he's the guardian ad litem.
Yeah, 15th, May 15th.
I can start at 11,
And then how long do you have?
rest of the afternoon.
Let's start at 1.
Painful, Jenny. Painful.
That way my staff gets to have lunch. Let's set it to 1 o'clock on the 15th. Because you can't come in. Do you have things in that morning that it can be 11? Mr. Long?
I have a 9:30 or 9 o'clock in Marsden.
Yeah, we can go. So 15th at 1, like I said. Mr. Reynolds, will that work for you?
Yep.
And Miss Liz, will that work for you? Yep. Miss Liz, I'm remembering correctly that you were currently pregnant by Mr. Sliskin.
I missed your week.
I'm so sorry.
Thanks.
But you're available on the 15th. That one. Are there any doctor's appointments for either of you that I need to be thinking about in terms of scheduling? I want to make sure sometimes it helps with prompting, but remembering. Any issue, but I should have to prepare.
No, really not actually.
So if she was recently pregnant, he's the father, but now he's with Sarah again, which means he was with Sarah before.
I just told her to stop, but there wouldn't be no issues I could bring up.
Okay. Well, I think if they have appointments or something I need to know about, please tell me.
I think it's supposed to be.
Okay. Hopefully with it being at 1.
It was her.
So yeah, okay. Do they get out at 2:30?
I get out at 2:20.
Okay, so hopefully they don't miss imagine for a little learning. Okay. Let's have the girls.
These comments are useless.
If it makes you feel comfortable, we can let dogs.
They love animals.
Okay. We have a court dog.
Court dog.
Outdoor animal. If it makes you feel more comfortable, bring it in.
Please.
So they're bringing the children into court next time. And they're going to have a court dog ready for the children if they needed the dog.
Okay. And I'll touch that anything. The dog can be out here. We need to, if the girls are nervous, but usually during this proceeding, I don't have to say anything. We usually ask them if she's in chambers. Okay. Any concerns about that? I need to know about? No. Okay. So we're going to be scheduling for 1 o'clock on the 15th. Will you please remember, we're going to be the day before our friend talk. Yes, sir. Anything else I need for today that I need to address, Mr. Long?
Your Honor, on January 8th, the agreement and the child support worksheet was filed in Odyssey. I don't know if it didn't get to you or.
There's no, I'm January 8th.
Okay.
Your report
bunnies.
was filed on the 7th.
They're very
That's just the
soft.
report. It's in any child support worksheets.
Okay.
Was there anything else on Mr. Long?
No, Your Honor.
Anything else for you, Mr. Long? Anything else for me, Ms. Liz? Thank you. Okay. Thank you all for being here. Thank you for your time. We'll see you back on May
15th.
15th. All right, we are. All right.
All right, guys, listen. We're going to go into Discord, into vocal vibrations in Discord, okay? So, what that means is if you go into Discord and you see on the left-hand side, there's all those text chats. Right below that, right below the long list of text channels, there's a voice channels. The first one is vocal vibrations. And you just get in there. If you have any issues, just talk in general. And we'll help you. We'll get you in. All right? Josh was supposed to be here for this too. And if you don't have time, don't come. It's just we could talk to each other for a bit. You can put your camera on or not. It's up to you. But thanks for coming out today, guys. I'll see you all tomorrow. Have a great day. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for